Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of Indraprasth Law College. Although we have already discussed the various topics in details in the previous lecture, and in the previous lecture we have discussed about the Austrian theory regarding the validity of international law, and see that what is the thoughts of the Austrian regarding the validity of international law, wherein he says that international law is not law properly so called, it is that's like a laws improperly so called. I think you have seen that video and understand the whole concept about the Austrian theory regarding the validity of the international law, and in this validity of international law, today we are going to discuss about the Holland's view regarding it, who says that international law is the vanishing point of jurisprudence, and that is also an important question in view of your exam pattern, and sometimes it may questioned in 20 or 10 marks. So basically that is a very important question, and Holland's view, after following the Austrian theory, went one step further and declared the same things. So now let's open the today's answer and see that what is the view of Holland in regard to the validity of international law. We have already summed up about the Austrian theory, the concept of Austrian theory in the previous lecture or this lecture also. And now we are going to discuss about the Holland's view. According to Holland, a statement prompted by Austrian theory, that is because one step further of this Austrian theory, Holland agree with that. And agreeing with Austin, Holland argued that international law lacks a sovereign legislative authority to lay down the rules of international law. There is basically no court with compulsory jurisdiction to try cases involving principles of international law. And finally, there is no machinery to prescribe and impose punishments for nations violating international law. That is basically the view of the Holland, which is already having a consideration of the Austrian theory and have an impact of the Austrian theory. Moreover, for Holland, international law is merely a moral code of nations, not having any binding force. So Holland says that it is a moral code of nations. For these reasons, he declared that international law is a vanishing point of the jurisprudence. But in spite of the criticism leveled by Austrian and Holland, the validity of international law has been vociferously defined by its supporters like Stark. On some ground, just like that, in the words of Stark. So now we have discussed about the opinion of Stark, who provides the criticism of the Austrian or the Holland theory, and understand what's the view of the Stark, who gives some grounds. And the first one is, he says that modern historical jurisprudence has discounted the force of the Austrian theories of law in general. Field researches conducted by anthropologists and historical jurists like Henry Mann have pointed out as to how without a sovereign law and legal system can function in a society. Austin's inconsistent on the necessity of a sovereign for international law is no longer valid. So absence of a sovereign in the international sphere need not deter us from conceding validity of international law. That is the first view of Stark. The second mode is that whatever might have been Austin's criticism of international law, it no longer holds good in view of emergence of multilateral conventions and lawmaking treaties. This has resulted in what may be called international legislation, comparable to the municipal laws of the state, reducing significantly the customary component of the international law to a bare minimum. So that proves that lack of sovereign has not significantly affected the growth of international law, which of late is assuming a greater binding force than during Austin's period. Now, the third aspect says that questions of international law have been treated as legal questions by those who conduct international relations on behalf of the state and not as moral questions. This is evidenced by the fact that they resort to the same legal technique like applying precedents which are followed in the municipal legal system. The fourth opinion in that regard is that validity of international law has been affirmed at various international conferences in recent times, and the Charter of UNO is based upon these principles also. So the UNO has also come in the existence, and the last one is that international law is a weak law. Nevertheless, it is a valid law. So after summing up all the things, it says that international law is basically a weak law. Nevertheless, it is a valid law because strength or weakness of law has nothing to do with the validity of the law. So the one part of the jurist says that it is not law, or the laws improperly so called. The other one says that that is the moral conduct of the nations, and the third one says that basically international law is a weak law. And the another lobby of the jurists says that it is not a law. So there is a four diversion in the international law. The first one says that international law is a true law. in regard to the validity of the international law. The second one says that it is a basically improper law. The third one says that it is moral conduct, moral law, and the fourth one says that it is a weak law. So 4 aspects are given in regard to the validity of the international law. I think you all understand the whole things very well, and you will have been enjoyed the whole session. So please successfully enumerated it into your study and be benefited from this presentation. We will meet soon again with a new session. Thank you very much.